Our first panel of the day, Canceling Student Debt for Students Defrauded by Predatory Schools, will be moderated by Jonathan Glader, professor at UCLA Law and co-founder of the Student Loan Law Initiative. Jonathan, take it away.
Thank you so much. Good afternoon, everyone, and thanks for joining our opening panel on canceling student debt for students defrauded by predatory schools. I'm a law professor here at UCLA, and I teach education law and policy. Our panel consists of a number of experts, and we're going to be focusing on a set of problems related to student loans, of course. In particular, unscrupulous higher education providers that deceive students into going into debt and then, often enough, collapse before the indebted students complete a course of study. These stories implicate multiple sets of regulations that govern when and how a borrower can assert a defense to repayment, BDR for borrower defense to repayment, regulations that govern what happens when a school closes on a student borrower, and regulations that require a school to certify that a borrower is able to benefit from the education provided. As with so many problems created by student debt, these deceptive acts and practices and school closures prompt questions beyond just the treatment of borrowers about how to regulate this sector. And those questions implicate the gainful employment rules, setting standards that schools participating in federal student aid programs under Title IV of the Higher Education Act that they must meet, and maybe other steps that we'll hear about to detect and deter potential misconduct. Our panelists are Eileen Connor, Legal Director at the Project on Predatory Student Lending at Harvard Law School and a contributor to the report on delivering on debt relief. Robin Smith, who's of counsel at the National Consumer Law Center and also contributor to the report. Tarek Habash is head of investigations for the Student Borrower Protection Center, and Jan Keo is a fellow at the Century Foundation. Barney Eskandari is supervising Deputy Attorney General for the California Attorney General's Office. I'm going to ask each of them to make some opening remarks in the 5 to 7 minute range, and then we'll have a conversation addressing some of the critical questions that their research and in some cases litigation experiences have raised. And I'm going to start with you, Eileen. Can you tell us a little bit about the kind of work that you do and about the findings in the paper that you and Toby Merrill contributed to the Delivering on Debt Relief report?
Sure, and thank you, Jonathan. Thank you to SBPC and to Demos for hosting this event. I think it's so important to be thinking about what can be done to bring this needed relief to borrowers. So I'm the legal director of something called the Project on Predatory Student Lending at Harvard Law School. I co-lead this project with Toby Merrill and a team of excellent other people. And what we do is we try to make it legally and financially impossible for for-profit colleges to rip students off. And so we're trying to use litigation to realign the incentives, either to make institutions internalize the cost by holding them legally responsible for deceptive acts and practices. And we're also trying to use litigation to ensure that those who are responsible for overseeing this federal student loan program are not allowing it to be used and abused by bad actors. So that brings us to borrower defense, which I think is kind of at the fulcrum of both of these things. We represent over a million former students of for-profit colleges in various cases. We have litigated against the Department of Education beginning under President Obama and continuing today, probably continuing into the next administration, just given where our litigation is. So borrower defense is something that is supposed to be a fail-safe for borrowers. When they take out federal student loans, they should not be obligated to repay them when they were fundamentally cheated because they didn't get the education that they were promised. This is something that's a matter of contract. It's in the higher education statute and it's in department regulations, and it has been for decades. We've only been hearing about it a lot in the past 5 to 6 years, partly because of the epic collapse of certain chains of for-profit colleges, and partly because of growing, I think, pressure on people due to student loan debt and the massive expansion of predatory actors within the system, people getting organized around their student debt and getting really loud around this issue. So since the tail end of the Obama administration, there has been some action. I think one thing that I wanted to highlight about borrower defense is that it really does have its roots also in this concept of the Federal Trade Commission's rule on the preservation of claims and defenses, which is supposed to act to police the marketplace so that a repeat player like a lender is going to make sure that it's not making loans for people to use to purchase goods and services from basically shady sellers. So in this instance, what we're talking about is the Department of Education being the repeat player. It's in charge entirely of what schools get to create loans for their students. And I think this has a special salience for students of for-profit colleges because that is the group of institutions that the FTC holder rule has always reached because they regulate for-profit entities. So the vast majority of people who have filed for borrower defense to date, and there have been over 350,000 people, and that's not even counting people on whose behalf an application has been made by an attorney general, have asked to be relieved from their loans because of school misconduct. So that's what borrower defense is. How has it been working? It really hasn't been working at all. There have been 3 institutions where students have gotten any cancellation. There's been a sort of a long period of non-adjudication followed by a very short time period in which over 90% of pending borrower defense applications have been denied in a really summary fashion. All of this has been subject to a lot of hard-fought litigation by certainly by my team and by others. So I think looking forward, what we need to think about for the next administration is what is the regulatory landscape? What tools are available on day one? What should the bases be for granting borrower defense? I think the thing is that in this larger conversation around debt cancellation and student debt, the thing that people seem to always agree on, no matter their position on that larger question, is that certainly people who have been ripped off should not be held to their loan obligations. They should get relief. The thing I think it's so important for people to know is that that has not happened. It has been clear as day that these schools have ripped people off, and it has been for a long time. It's been acknowledged by the department. For example, if you think of Corinthian, most people probably assume people with Corinthian don't have any debt anymore. That's just not true. The Department of Education under Obama identified over 300,000 people who should have their loans canceled under borrower defense. Less than 10% of those people today have actually gotten cancellation, and half of those who have gotten it still have remaining loans to repay because they've been subjected to this partial relief formula. So I think it's really important to understand how much this tool has really not come into being because of, I think, partly sort of a hostility of the current administration towards the whole notion of debt cancellation, but also because it hasn't been conceived of in the way that I think that it really needs to be in the spirit of the FTC holder rule, which is a means of making sure not only that schools aren't ripping people off and that we aren't asking people to repay loans where they really are legally not obligated to, but it's meant to force the Department of Education as a regulator to be accountable, to say, we're the one who decides upfront which schools can create this kind of student loan debt. And when we mess up, even if we couldn't have known at the time, because a lot of our regulatory ability, it's backward looking. But once it becomes apparent, borrower defense is there and it has to be used to take the risk of failure where there has been failure off the backs of these individuals who just are really not in a position to bear it, and onto the Department of Education itself. Yes, we should try and recoup money from institutions when we can, and I know we're going to talk about that today. That's something that people on this panel have thought a lot about. But the number one thing is, it's not okay for the Department of Education to act as though it has no role to play and to continue collecting from people in the face of this really widespread and established school misconduct. I think I turned it back to you.
Thank you, Eileen. We are gonna, I suspect other panelists will be picking up several of the themes that you've introduced. Thank you. Robin, moving to you, you also contributed a paper to the report. Can you tell us a little bit about the kind of work you're doing and also about the argument of the paper?
Yes, thank you, Jonathan. I'm a senior attorney at a poverty law organization in Los Angeles, where I provide free legal services to low-income student loan borrowers. And I also work as of counsel at the National Consumer Law Center, where I work on these issues at a policy level. And I just want to start out by sharing a story that is emblematic of the many, many student loan borrowers I have assisted over the past 20 years. I have a Latina client who was in the 6th grade when she was removed from her home and placed in the foster care system. For the next 7 years, she was moved between foster homes so frequently that she never completed another grade level. In 1985, she was homeless and 18 and recruited off the street to attend a Delphi Business College. 2 weeks later, after she had taken out student loans to attend the college, the school closed. Over the next 7 years, she struggled with mental health. 2 more for-profit schools recruited her off the street. Because she had not earned a high school diploma, she was eligible for federal financial aid unless each school certified her ability to benefit from her education. Federal law at the time and currently provides that non-high school graduates are not eligible for federal financial aid unless the school certifies that they actually have the basic skills, math, reading, writing, to succeed in their education. These schools did not do that. They did not follow federal law. Despite that, they took out student loans in her name, and she dropped out of both schools shortly after attending because she could not read or write. Both the department and the California Attorney General's office determined that both of these schools engaged in widespread fraud, but my client had never been told that she was eligible for any type of debt relief, even though she's eligible for false certification discharges and closed school discharges. She has suffered from decades of involuntary debt collection and still has a debt balance. She's currently still struggling with homelessness and is luckily in transitional housing at this time. This is not a single case. I have seen this across the country in my role as NCLC and at my office here over and over and over. I want to mention that this is a civil rights issue. Sudden for-profit school closures and false certification fraud disproportionately harm Black and Latinx people. These are students who start out economically disadvantaged by the historical structural racism that is embedded in our economic system. They do what our society tells them to do, and they go to college to improve their economic well-being. They trust that because our federal government has said it's okay for these schools to get student loans, that these must be good schools. They study and they work hard to succeed, and then disaster hits. The schools close, the schools illegally get them debts even though they haven't graduated from high school. And another type of debt that is clearly a civil rights issue is students who have the legal status of having criminal records often cannot obtain jobs in certain industries. Schools are not supposed to enroll these students either if they know that their criminal records will prevent them from getting jobs. Yet most of these students also get federal debts that they cannot discharge, even though the Department of Education has the authority to discharge those debts. And these students end up in a worse financial position than before they enrolled in college. This isn't just a financial setback. This is a lifetime setback that to these students, their families, and their communities. I did a report about closed school discharges, so I'm going to focus on that. Based on the data available from recent school closures, we know that probably a majority of people who are eligible for false certification discharges over the past 35 years have not gotten those discharges. This is despite the fact that the department has both the statutory and regulatory authority to grant automatic discharges, meaning it can grant discharges without requiring applications from student loan borrowers. And in fact, it has in its possession or in the possession of the loan holders, the data it needs to actually identify these borrowers and grant them closed school discharges. However, it has not done so, and it has not done so for over 30 years. There's no reason to collect debts from these people. They can't afford the debt, first of all. Second of all, they are not the ones who failed here. It is the Department of Education and the schools that failed. So the question is, why are we doing this? Why are we continuing to collect debt against these people? And I think this gets to what Eileen mentioned, is we have to incentivize the department to internalize these costs. We have to incentivize it to do the right thing to prevent these kinds of failures in the first place. And what I posit is we need to, looking forward, instead of spreading the cost of this over time, meaning right now when a school closes, that isn't a hit to the budget because the department can keep collecting forever until those students actually apply for a discharge, right? So the public doesn't see a big hit on the budget. If there was a big hit, so if the department was forced to take an immediate loss for all of those students that were affected by the closure right away, there would be an outcry from the public, and perhaps the department would be better incentivized in the future to avoid that. And I'm positing that all of those students should immediately get discharges, regardless of whether they enroll in a teach out or enroll in transfer credits. Let's remember here that the purpose of the Higher Education Act is to support students and ensure that they can get a quality higher education regardless of whether they can afford it. That's not happening. And so we just need to incentivize the department to do a much better job. And I will end with that. Thanks.
Thank you, Robin. This actually leads nicely to Yan, some of your work, because you've looked at school closures and in particular about some of the warning signs that precede closures. And I wonder if you could briefly describe some of your research and share your findings and especially your recommendations for a more proactive, forward-looking, right, recognition before the problem, how to better police schools that are at risk of collapse and leaving borrowers in the predicament that we've heard about.
Yeah, thanks, Jonathan. And I'm so glad and thankful to Student Borrower Protection Center for putting this together. I don't know about you all, but I've been trying to figure out how to fix my face because I'm so thrilled to be on a panel with these wonderful people who have taught me so much about advocating for students around student loan debt. But the things they're saying are so horrible. So I'm kind of bouncing back and forth between joy that this is coming together and continued frustration and outrage that the things are happening out in the world. So I want to start by kind of positing this question, why do schools close? And I think the answer is really gradually and then suddenly. And part of the problem, if the theme is kind of how do we get the department to internalize some of the costs associated with their bad regulation and enforcement of student loan debt, is that when schools close, the department tries to step in during the suddenly point when everything is already kind of collapsing. And almost always prior to that sudden closure, there's a long lead up. There's that gradual process during which time state attorneys general are filing lawsuits. Students are filing complaints through a million different avenues because they're not sure if they should be complaining to their attorney general or their state authorizer or their accrediting agency or through a borrower defense. Student simply doesn't know. And unfortunately, in most of these complaint channels, they never hear back and nothing good happens. So why bother? And that's a problem as well. I think the really key aspect of protecting students better from sudden closures is to start paying attention earlier. And I think there's a day one piece of this, and then there's a beyond piece of this. And I'm going to start with the beyond piece, which I think is really establishing a virtuous cycle that has three components, and I'm going to call them the 3 C's. So right now we're going to start with cancel the debt. That's kind of obvious, and especially in the forms that Eileen and Robin have spoken about, that's not day one. That's like day -100. A lot of these debts, the Corinthian debts, should have been canceled 4 years ago. All of the legal requirements have been met and exceeded. And the students have been, really just waiting. So 1, cancel the debt. 2, cut off bad actors. 3, claw back wealth. And so it needs to kind of be all 3 of those steps. Right now, because the enforcement to cut off the bad actors isn't happening, there also isn't a clawback of wealth. And so the only place to start this cycle is by canceling the debt. And then we can start to feed into this cycle, because if you look at the basis for borrower defense relief or for false certification relief, it's that the school did something unlawful. And guess what? Under the Higher Education Act, when the school did something unlawful, they're not really eligible to continue to receive any taxpayer money anymore. That's not happening, but that's the enforcement piece that I'm talking about when I say cancel the debt. When I say cut them off. Enforce the aspect of higher education law that says, hey, there's all this taxpayer money. It's not just for us to hand out. It is part of a contract with schools that they have to provide these services to students in order to be eligible for this taxpayer benefit program. And in both closed school settings and borrower defense settings, the idea is if the school isn't delivering the goods, why should they get paid? I think part of why these things aren't happening very well is because the department also isn't clawing back money, which I just want to speak to for a second, because, I think that an initial step is to internalize for the department the costs of its oversight failures. But ultimately, we do want to shift those internalized costs from taxpayers, which will be initially funding the relief, to the bad actors, and particularly those executives at the top of the organizational structure of bad acting schools, so that they're eating some of the costs themselves, especially when we know that they are profiting enormously from ripping off schools to begin with. When I say claw back, I want to stop there because that's also a lot of the day one actions that the department is currently authorized to do and just isn't doing. 3 ways to start clawing it back. One, start using personal liability enforcement so that a school can't just file for bankruptcy and have the executives run off with the stolen goods. 2, there is authority for the department to require schools that are risky to buy an insurance policy on behalf of students and taxpayers. Currently, they're doing a horrible job of making sure that schools have to buy those insurance policies and to buy them at appropriate levels. And I'll say 3 is a third piece. Many schools that are in that gradual phase of heading to closure are already in a status where they're basically on probation with the department, which means the department should be looking more closely at what risks they're doing and stepping up the requirements for these schools to make sure that they're either in a process of winding down and safely teaching out students or closing sooner rather than later. It's going to result in less harm to students.
Thank you, Yan. Turning to Tarek, one of the themes in the report and also in Senator Warren's remarks at the outset were the disproportionate effects of predatory schools' conduct, deception, closure on student borrowers who are people of color. And I wonder if you could again, describe your role at the Student Borrower Protection Center, and also tell us a little bit about some of the research you've been involved in that's helped reveal those disparities.
Yeah, absolutely. Thanks so much, Jonathan. And just for those who don't know me, my name is Tarek Habash. I'm the head of investigations at the Student Borrower Protection Center. And so what that means is I spend a lot of my time just really digging into the various failures of the government, for-profit schools, of the companies that prop up for-profit schools and allow them to continue to exist and prey on students, and predominantly and disproportionately students and borrowers of color. And I think over the last few years, some of the most evident things that we have realized has been this disproportionate effect of student debt and the effect of for-profit schools on students and borrowers of color. I think Senator Warren, like you said, really hit this home that this is a racial justice issue. And I think this issue is compounded by the predatory practices of these schools. I think Robin's story was extremely salient here in how just one of her clients was affected by a series of schools and being preyed upon turn after turn, offering extremely low quality or no quality education and putting this individual in massive amounts of debt decades later, still not having been relieved of this debt. And I think Eileen also kind of hit on this. Like, this is very much something that everyone across the spectrum, whatever your thoughts are about the student debt crisis and providing broad-based cancellation and relief for those borrowers, this is the issue that I think is the lowest bar that everyone agrees that no matter what your perspective is on canceling $10,000 or $50,000 or all of it, like, we should not be collecting the debts of borrowers who have been ripped off by predatory schools. And unfortunately, what we've seen for the last administration, and even before that for the last decade plus, has been this unwillingness to remedy these borrowers who never should have been driven into this debt. And it seems so obvious and like such like an easy thing for us to say, okay, well, we should stop doing this. But it has taken us this long, and it's taken us multiple administrations seeing failure after failure. We had a Senate investigation almost a decade ago looking into the widespread abuses and failures of predatory for-profit schools that investigated almost 24 corporations and issued a 1,000-page report that was scathing. And yet we continue to collect on the debts of students who were enrolled at these schools, who were preyed upon by deceptive practices, who were lied to through the enrollment process, who are given absolutely no quality education, whose loans have by and large defaulted because they don't have the means or the ability to be able to repay these debts, and they were lied to. These companies or these schools are hiring companies to drive these borrowers into forbearance so that they can continue to collect on them, or so that they can continue to collect future student loans because they're not hitting certain thresholds according to like the statutory requirements. And I think Betsy DeVos certainly made this worse, but this was an issue even before that. And I think we're at an inflection point today because we have elected a president and a vice president who, for the first time in my lifetime, are going to prioritize student debt, and who are going to talk about it not just as a higher education issue, but as an equity issue, as an economic issue, as a racial justice issue, and as a generational issue. For the last year, we've heard President-elect Joe Biden go out on the campaign trail and say, enough is enough. It's time that we actually fix this broken system, that we make borrower defense work for students who have been ripped off, that we provide relief for millions of Americans who have been failed by a broken system, and that we hold for-profit schools accountable. That is the very least that we can do. It's something that we can do immediately, and it's something that we must do if we want to actually start to see this system of higher education work for Americans. It is the minimum, and I'm really excited that we're all here. I'm so glad that everyone has been contributing to this work for all these years, because we would not be where we are without the advocates, without the borrowers who have been talking about their stories, and without the legal experts who have been pushing this issue for the last, I don't know how many years now. So thank you.
That's a perfect segue to the question I want to put to you, Barney, because you've been in the trenches in pursuit of bad actors in this area. You've been litigating extensively, and I would ask you to describe some of your work at the California AG's office briefly, and maybe also give a sense of why we see these predatory schools targeting particularly people of color.
Thank you so much, Jonathan. Really happy to be here and humbled to be on this panel with wonderful, wonderful people. So I'm Barney Eskandari. I'm a supervising deputy attorney general at the California Department of Justice. I've been here nearly 10 years. I started just after now Vice President-elect Kamala Harris was first elected California Attorney General. Predatory schools and student debt issues have been a major focus of the office since I've been here, and I've been heavily involved with that work. And so I'll just briefly run through some of the highlights. I was part of the team that prosecuted Corinthian colleges, resulting in the $1.1 billion judgment that ultimately led to Department of Education findings that should have resulted in mass borrower defense relief, but was cut short with this change in administrations. Our office has a pending action against Ashford University, another massive for-profit school. We've sued Navient for student loan servicing misconduct. That action is pending. We've gone after a number of private student loan lenders and holders of those loans. You know, our state law tool chest is somewhat limited, and I will touch on that briefly. But as far as private loans go, we can go after the holders of those loans, and we've been pretty successful in getting near complete discharge of hundreds of millions of dollars of private student loan debt. We've even brought our criminal tools to bear. We recently brought criminal charges against a group of individuals who were allegedly running a debt relief scam that involved hacking in or unauthorized access to Department of Education computers, servers, in order to change borrowers' data. Ed's Office of Inspector General actually cooperated with that and was instrumental in that investigation. But our tool chest is limited. So federal student loans, only the federal government can discharge those loans. And so when the federal government falls down on the job, there's little recourse, at least, that state enforcers can do. And so one of those limited avenues is to sue the Department of Education. And so over the last 4 years, we have repeatedly sued the Department of Education, and maybe can touch on that a little bit later in the panel, but you know, the APA is a powerful tool and states have standing under it, and we have, you know, been involved in, I think, 6 lawsuits against the federal government. So to your question about predatory for-profit institutions preying on people of color, you know, it's a consistent theme in our investigations and prosecutions that predatory for-profit schools actually intentionally target, literally as part of their business models, the most vulnerable members of society. That includes historically underrepresented, those who've been underrepresented and blocked from higher education. And that group overwhelmingly includes people of color. And there are structural and historical and economic reasons for that that are all been touched on. The others fall into this category too. They're not the overwhelming majority like people of color, but single parents, immigrants, service members, those living at or below the poverty level, they're also aggressively sought out by for-profit schools. In our Corinthian investigation, you know, we got their internal documents, and one of them described, you know, their target demographic in really heartbreaking terms: isolated, impatient, those with low self-esteem, those with few people who care about them. You know, these schools are looking for people, prospective students, who don't know how bad the schools are and who are without people who can assist them to know how bad the schools are. And so vulnerable populations, especially people of color, that have historically been shut out of higher education, are the primary pool for predatory schools to prey on. It's really quite heartbreaking. Those are my intro comments, and I'm really looking forward to the panel discussion.
Thank you so much. That's actually a great segue to the first question I want to put to the group. And whoever would like to respond first should please feel free to do so. And we've heard a couple of times now about the criticism of the Federal Department of Education for inaction in this area, even given the tools that we now understand from our experts are available to the department. And so they failed to help borrowers who in many cases are entitled to protection because they were deceived, because the school closed. So the question I put to you all now is, can you describe a little more about what the department in particular has chosen not to do, has failed to do, and what can and should it do in these areas going forward? And this is kind of thinking, and please feel free, don't feel obligated to break your responses into, you know, the day one, the first 100 days, what calls for new rules. What do we want to see the department doing going forward?
So I will quickly jump in here, and I think others will have, I think, possibly more insightful things to say. But as far as I can tell, for the last 4 years, the department has failed to do anything except seek ways to thwart relief to defrauded students and repeal Obama-era regulations that protected students. I mean, I think it's just that stark. And so here are three things the department can immediately do, and I'm sure there are more. This is a theme that's come up repeatedly. Process the backlog of hundreds of thousands of borrower defense claims. These claims are subject to the 95 rule, the 2016 rule, the horrendous 2019 rule that the current administration promulgated. Almost no loans are going to be subject to that rule because it only applies to loans first dispersed after July 1st, 2020. On top of that, is, I believe Eileen mentioned, there's the master promissory note, the holder rule applies. So there's nothing stopping the department from processing this backlog immediately on day one. Closed school discharges come up. There's nothing stopping the department from automatically granting closed school discharge. This administration has been hostile to it. I really hope the next administration is not. And finally, make loan servicing work. A properly functioning loan servicing system can reduce the pain that borrowers are facing. This means at a minimum ensuring that people are properly put in income-driven repayment programs, which for some borrowers are going to yield $0 monthly payments, and that public service loan forgiveness and the temporary expanded program are working as well.
Others want to jump? I see you. I'm unmuted. Eileen, please.
Yeah, thanks. So I think something that needs to happen, and what the department has failed to do, is to use the broad authority that it has to administer borrower defense, and that includes doing it without application, doing it at the request of an attorney general, doing it on the basis of common established facts and evidence. And I think that for example, I think that there's just been a real misperception about what the true threat is here. So the true threat to the federal student loan program is not that a borrower who went to HEALD in California may get borrower defense relief, but did not actually rely on a published placement rate that was misstated. But that was the concern. The concern was we can't possibly let anybody get loan cancellation until it is proven beyond a certain threshold that they themselves are worthy of it. Instead of asking, what right does the Department of Education have to collect this loan in the face of all of this evidence? What sense does it make to require people who the department's own analysis show are living at or below poverty after having gone to these schools, making less than they did before, making less than somebody with just a high school education? What kind of a windfall are we protecting against? The real threat, I think, to the federal student loan program is a lack of public confidence that the department is actually a good steward of this program, that people are going to be able to, as Robin said, like listen to the message that we give people that higher education is a really safe bet and a really worthwhile endeavor, because they're going to see, for example, that the Department of Education will let companies pocket the money, declare bankruptcy and walk away, while students, they will chase them until they die and take their earned income tax credits, take their wages if they're even lucky enough to be able to work in service of this debt. So I think taking the most legally conservative position has been the default of the Department of Education. And I think that's something that just really needs to change going forward. And I think specifically what that looks like, discussing the options in the paper, but they need to, on day one, at a minimum, they need to reopen every single borrower defense application. They need to retract the partial relief policy of this administration. They need to look at any grounds for granting every single pending borrower defense application. And I can tell you that the conduct of this administration under DeVos in any normal circumstances would make the debt uncollectible because of the illegality with which this program has been administered. And I think there's a clear opening to do that based just on the misconduct of DeVos alone. I mean, we all know that the Trump administration really loses every single time it goes to court, and it doesn't really care about following the law, but there's only one head of an agency under President Trump who has been held in contempt of court, and that's Betsy DeVos. So like the door is open, it needs to be walked through. You shouldn't look back. You should make bar defense more accessible and more broadly granted going forward. I think that that's the imperative here.
And I just want to piggyback on Eileen. I think we need to change how we have to flip on its head how we view this whole system when a school collapses. Instead of putting the burden on borrowers to prove that they didn't somehow benefit from their education, we need to presume that they didn't, and absolutely wipe out the debt and give them a fresh start. They are not the people who did anything wrong here. And to pursue them as if they are somehow at fault, which is what we do, that's the narrative we have, is that if they're not paying their loans, even though they went to a terrible school, they're at fault. We need to reverse it so that from the minute there's an event that reveals that a school has defrauded thousands of people, whether it's an AG judgment or a findings by the government or a school closure, immediately the government needs to wipe out those debts from day one. Take that hit and either retract that money from the school or pay for it itself. We need to just change the narrative completely in the way that we approach these situations. And I would posit that the department currently has the statutory authority to do it. It can clearly do that for false cert and for closed school discharges. With some minor, I would say, regulatory changes, it also has the authority to do that when there is state law or federal law violations. But again, there may be some regulatory changes that have to happen, but those changes can be made by this administration and should be something that they focus on from day one as well.
I know time is short, but I wanted to add an enforcement point and a policy point in terms of some immediate actions. So we've talked a bit about borrower defense and the examples of ITT and Corinthian, where broad fraud was established, and there's a lot of claims and a lot of borrowers who need relief. I have a piece that I never published. It's called DeVry Owes Taxpayers Millions. Why won't DeVos collect? So DeVry University is one of these examples where there's an FTC case joined by a lot of state attorneys general. The school settled for $100 million, claims that they lied to students about the earnings and employment outcomes for years. The Department of Education made findings that the school engaged in misrepresentations. If you put together end to end the debts of the students who took out loans during the period of those findings, that the school engaged in unlawful behaviors, you have about $1 billion of relief. And so this is the school where there are the most bar defense claims that is still open, and the department needs to start collecting money from DeVry to make sure that they get some money back of what they have sent out to students when they start to provide relief to students who've been defrauded there. That's one aspect. I think as a policy matter looking forward, it's really important to enforce something called the incentive compensation ban, to take away some of the structural incentives that have been leading to frontline misrepresentations to the student by the person who's trying to convince the student to enroll and take out student loans. So the idea of the incentive compensation ban is the salesperson shouldn't be working on commission. Unfortunately, it's only been applied to kind of the lowest level person in the massive coordinated scam. So if you pay an enrollment recruiter a bonus for taking in 1,000 students, that's unlawful. If a for-profit school makes a lot more money because they enrolled another 1,000 students, that's fine. If a nonprofit school decides to contract with a for-profit company to enroll another 1,000 students, that seems to be fine too. And that last piece is not statute, it's not regulation, it is guidance. The Department of Education's IG has said it's guidance that conflicts with the language of statute, and I think that's a place to start with policy on day one. Also a place where litigation might be able to help push that policy along.
And John, if I can just weigh in very briefly, just on the moral imperative here, and I think everyone kind of hit on this, but I think we just have to remember that like people's lives have quite literally been destroyed here. this needs to be something that is immediate. I think Eileen, Robin, Barney, Yan all said this. Like, we have led entire generations to believe this dream that there's this promise that, like, if you go and seek higher education and you get a degree, you are going to be able to pull yourself up by your bootstraps, and you are going to be able to provide for your family. And we have allowed scammers for decades to prey on this promise without holding them accountable, without regulating them properly, without ensuring that their accreditation means something. And we've let them systematically prey on millions of Americans. And we blame the borrowers. We've said, you are still responsible for this debt. There's this like mythical social contract that only applies to borrowers, but not to the government for failing to hold schools accountable, not to hold the scammers accountable and make sure that they're actually providing what they're promising students. And I think that has caused, as I can't remember who it was that said this, but there's a responsibility that we have to the borrowers to make them whole. And like, this needs to be done immediately. We can't wait on this. So
Tarek, your comments bring to light again sort of the structural issues that we should be worried about. And so the next thing I want to ask is putting aside for a moment existing authority, right? And this is not to say that we don't require immediate action. I mean, people are suffering right now in concrete and measurable ways. But from a rulemaking perspective, what more would you want to see out of this administration? I'm wondering not just about borrower defense here, but also about restoration of gainful employment, which we haven't really talked about, and that I know all of you know a lot about, and perhaps regulations in other areas as well, that would go towards assuring more equitable access to education for the populations right now that are being preyed on, as Barney put it, by unscrupulous actors. I mean, what kind of regulations should we be hoping for?
yeah, and I'll just throw a couple out there quickly. So we've talked about the restoration of gainful employment, but I think there is an opportunity to also expand what can be done here in terms of providing borrowers with actual relief. There's an ability to benefit provision within the false certification rules that Robin has already talked about. And I think there's an opportunity to say, like, for borrowers who are attending schools that are failing that gainful employment metric, you are clearly not, you do not have an ability to benefit. Your school has not actually done the minimum to allow you to be able to repay your debt, let alone to see a benefit from the program beyond that. You aren't really able to support yourself and your family if you can't even meet the minimum ability to repay your own student loans. So I think, like, tying those together and providing explicit relief for borrowers who attended those schools and programs who failed that metric needs to be near the top of the list. I think separately, I think closing some pretty critical loopholes that allow schools to evade important rules and allow them to continue to bring in pretty significant amounts of federal student loans. Evading the cohort default rate, for example, is something that we need to make sure we hold the schools and the companies that they hire accountable. And then I think separately, just making sure that we strengthen the quality assurance system that we have through accreditors to ensure that they're actually evaluating whether schools are appropriately providing high quality educations to students and rooting out schools from the student loan system that are putting students in massive amounts of debt, but not really providing anything substantive.
Eric, real quick, and this is my fault, can you, in like 30 seconds, just explain the gainful employment rule?
Sure, sorry. So the gainful employment rule is based in the Higher Education Act, where essentially if you are providing a vocational training program or something related to career advancement, you are subject to the gainful employment rule, which looks at a debt to income ratio and evaluates on a programmatic level, not an institution level, whether the program is actually producing a certain, essentially determining whether your graduates, it's only evaluating your graduates, by the way, whether they are able to earn enough money to repay the debt that they took on from the school. And so it looks at the median levels and makes sure that people are able to actually afford the education that they're taking on.
Got it. Thank you. And I know, Yan, you were waiting to jump in, and then Robin.
Okay, so structurally, it needs to be easier for people to sue the Department of Education. One of the reasons why they are so resistant to using some of this authority that they have is because sketchy schools are lawyered up. And if you say, hey, we're going to use this authority that we have to request more money from you or to cut you off, best be sure they will be threatened with litigation. But on the other hand, when they say to students, hey, we're going to withhold some of this money from you, they aren't sued and they aren't threatened with litigation in the same way. And so I think that's one of the things that needs to be structurally changed. There are a few ways to do this, but one is that the schools owe fiduciary duty to use Title IV funds in a way that advances the goals of the Higher Education Act. And, they could deputize private individuals to kind of help enforce that fiduciary duty.
And one thing I wanted to mention was I think what the department can do from day one is to staff up and create a really strong law enforcement section. The department doesn't have one. The way it monitors schools is through program reviews and audits, but it doesn't have a unit that's specifically tasked with identifying the riskiest schools and investigating them. It needs to hire seasoned law enforcement folks, investigators, and attorneys who are in a separate unit so that they're not compromised and they have a very clear position of what they need to be doing. And so I think that also should be a priority from day one to sort of start in on finding the for-profit schools and taking actions against the ones that are currently engaging in fraud.
Eileen, sorry.
Yeah, just going back to talking about regulation, I think that as it relates to borrower defense, what the statute requires is that the department specify in regulation what acts or omissions of a school would create a borrower defense. And so it's not the case that those regulations need to be labeled themselves borrower defense regulations. And I think that there's room in new rulemaking, but also using guidance and directives to designate program integrity regulations that have been discussed here, like the incentive compensation ban, like gainful employment, as themselves giving rise when they're violated to a borrower defense. And I think that that would do a lot to enhance program integrity and to make sure that that we make borrowers whole when they aren't getting what they bargained for.
The other dimension I want to ask about in terms of the Federal Department of Education under the new administration is there's a possibility, Barney, I'm looking at you, that you won't have to sue them anymore to get them to do things that might be favorable to borrowers' interests. So I wonder if you could say a little bit about how the department could work with states instead of finding themselves the defendant in suits filed by states over treatment of student borrowers, both by the servicers and by some of these institutions we've been talking about.
So thank you. I think one of the most productive sort of examples of state Department of Education cooperation is out of Corinthian. And so, findings for us are very expensive and resource intensive. What I mean by that are findings of fraud or misconduct by a school. But findings are the name of the game. That's what leads to judgments, and findings are what lead to borrower defense relief. So in Corinthian, we issued document requests and went document by document through a painstaking process and real sort of gumshoe detective work in order to develop, establish widespread gross misrepresentations of job placement rates. We were then able to share those findings with the Department of Education, who could bring their tools to bear by finding Corinthian, putting Corinthian on heightened cash management. The tool chest that Ed has could then be brought. And then, based on those findings, we can bring enforcement actions and get restitution, injunction, and penalties against the school. But it's all about the findings, and it needs to be a two-way street. So we do a lot of the work and we share it with Ed. Ed also does a lot of the work, and before the last 4 years, they used to share it with us and we could bring our tools to bear. And so I'm hoping that on day one, the sharing and the cooperation opens back up again, because that's a real way to protect borrowers, put these schools out of business, and ensure the system is working.
I have one last question that I want to throw out, and I'm asking it now because I want to give everyone a chance to weigh in on this one. And this one's really about advice to our audience. What can people do to further the goals of administrative debt cancellation in the current political moment? People who are inside government, people who are outside government, researchers, members of the public, advocates. What are steps that you all would like to see people try to take to support some of the policies and practices that we've been talking about?
Go. I would encourage people who've experienced these practices to call their congresspeople and their senators and share their stories. Congress isn't going to hold the department accountable until it really hears your stories and knows what's going on. And really, you should be flooding their phones, whether they're Republicans or Democrats. They need to hear you. And if they hear from enough of you, that really is what I think is going to push change. So that would be my immediate response to that question.
I think use existing authorities to sue the Department of Education, create counter pressure to the threat of lawsuits from schools.
I think it's really important for the incoming administration and people who are in policymaking roles to center the experiences of borrowers and to make an effort to hear from them. We know that they hear from industry all the time. There's not an organized funded lobby on behalf of students. We try and do what we can with our litigation. But I think it's really important to overcorrect for that and to make sure that at every step, you're reaching out and trying to hear from and understand the experiences that borrowers are having and have had, because I think that that's the only thing that's going to align the policy to the reality that as Tarek said, people's lives have been destroyed, and to do nothing is just to be complicit in that, and we can't do nothing.
Yeah, and I think there's certainly a lot of people who have been working on these issues for years, and borrower stories are some of the most impactful things that can really move the needle for policymakers to understand how serious of an issue this is and how widespread this is. Kind of as Eileen said, I think there's a new administration coming, and I mentioned this at the top. There's an inflection point where we have potentially the most progressive incoming administration on student debt and on higher education. And I think there has just been a decade, if not longer, amount of time of just almost paralysis when it comes to providing relief for borrowers who have really just been failed by the system, but in particular, borrowers who have been preyed upon by predatory schools. And, this is not going to just happen by itself, however easy we think connecting these dots are. And we need to be pushing from all sides. It can't just be the borrowers and the advocates on the outside. If you're on the inside, if you are working in this administration, you need to be fighting for this every single day, because it's not going to just happen. We all have to make it happen.
Anyone else with additional thoughts on steps people out in the world can do to help push this along? Okay. Then, since we have one additional minute, I'm gonna add one to this, which is the political economy question, which Tarek, you were just hinting at, right? I mean, so we don't know yet who's going to control the Senate, and obviously that's a factor on the legislative front. But I mean, can we guesstimate what's the likelihood of all of the kinds of measures we've been talking about in the coming really months?
Yeah, just really quickly, I think on the campaign trail, now President-elect Joe Biden made it clear that this was a priority. And as I said from the beginning, this is like the easiest thing for us to get done, because I think there is clearly bipartisan support for this issue. Republicans even voted for the Congressional Review Act to undo the Betsy DeVos rule. So there are even people on the Republican side of the aisle who support providing relief for defrauded borrowers. The time is now. Put your money where your mouth is. Get this done, period.
I also want to add that there are some great advocates in the room who've been paying attention to all these points and are, we're preaching to the choir a little bit. But I encourage those folks to consider working in the Department of Education. Robin said that there needs to be an enforcement team, and I encourage people to, help build something that's stronger than what we've ever seen in the department before.
So we're at time. I want to thank the panelists for bringing, really remarkable perspective to these issues, both the very high level big picture, but also really into the weeds. I want to thank the Student Borrower Protection Center for helping put this together, to Demos for helping put this event on and pushing this conversation forward. And I hope that the points that have been made here, the analyses of the problems, the proposals for action in very concrete ways going forward, will help us move closer to the fundamental goal of the Higher Education Act of greater equity and access to higher ed. For those who want to learn more about these proposals and others made by others on panels later in the day, please take a look at the full report, which is at protectborrowers.org, so that we can take steps toward addressing this student debt crisis. Thank you all.